The same, Mr. Board Member. I'm fine. How are you?
Okay, I think that we're now ready for our meeting. It's now 9:09 a.m. on August the 1st, 2013. I'd like to welcome everyone here, all the participants and our guests. The first item on the agenda is to call the meeting to order, which I've just done so. The second item is to adopt our agenda. I hope that the members have had an opportunity to review the agenda, and at this time the chair will entertain any additions, deletions, or corrections to the agenda. I don't know. Have anything? Jay? Okay, the chair would like to add a couple of items. Under old business, I'd like to add the review of the revised applications that we talked about last time. I think we just need to speak about that a little bit further this time. Under new business items, the chair would like to add a letter that members have received from Larry Doss that we should discuss. We also need to add an item. This board now needs to, as a formalization of travel, needs to have a vote on the members that will attend the NCEES annual meeting. Also do this in the future for other meetings, the Southern Zone and so forth. Also, the chair would like to add one other item, is to discuss mapping and platting standards in regards to legibility for registrars. No other items. If the members would concur with that, then we would need a motion to add those items to our agenda. In a second. Do we have a second?
A second.
All right, we have a motion and a second. Is there any further discussion? If not, I'll call for the question. All those in favor?
Aye.
Opposed? Okay. Those items have now been added to our agenda, and we will incorporate those through the course of the agenda. The next item is a new statement. This will be the first time that I've read this statement, and probably will not be the last that it'll be read. And it reads as follows. This regularly scheduled board meeting is taking place in Conference Room 1B of the Davy Crockett Tower, 5000 James Robertson Parkway, Nashville, Tennessee, and a notice of this board meeting was posted on the Land Surveyors website, and it goes on to indicate the site, on July 9, 2013. So, having said that, I think we're now official, so we may continue with our business. Next item on the agenda is to approve the minutes. Hopefully the members have read. It's probably the most lengthy set of minutes I have seen at a meeting in a long time. Dennis, you did a fine job on them, very thorough. So do the members have any comments in regards to any corrections or additions, deletions, etc.?
Well, I read through them, and I didn't find any, but my memory is short. But I make a motion that we approve the minutes as submitted.
I did want to ask a question,
Okay.
Galen. Over just before we get to new business on day 2, we had talked about possible licensure of photogrammetrist and bounced around some numbers. And there's a number here. It says Mr. Northcutt indicated that close to 1,400 licensees were grandfathered in these states. And I did not remember that statement whatsoever, and particularly that quantity, page 20. Page 20, right in the middle of the page.
Yep.
I may not remember the number that you mentioned either, and that's okay. But I just didn't remember it being, certainly didn't be that large. The reason being was, I think, if I recall correctly, when we talked with the folks from Virginia, I think they said they had 157, I think was their number. Florida was 130-something, I believe it was, when we talked to those folks. So that's why that, North Carolina was about 110. That's why the 1,400 just stuck out at me. It's not a big issue, but
I don't recall that I made that particular statement.
I mean, it's not a big deal. I just was.
There may be 1,400 nationwide, but as far as I know,
Right.
I don't know of any.
Okay, well, that's fine.
If we want to delete that, then that's fine with me.
Okay. I think if it's all right with the members, we'll strike that statement. And if other additions or corrections or anything? Okay, if not, Chair will entertain a motion for approval.
So moved.
Second?
I'll second it.
Okay, we have a motion and a second. All in favor?
Aye.
Okay, opposed likewise? Okay. Next item on the agenda, and I want to reverse the way it's written. The most important thing, as far as I'm concerned today, is I want to welcome Jay Kaufman from the Memphis area as our new West Tennessee representative, and extend our appreciation for your willingness to serve on this board, and hope that that it will be of a positive benefit to you as much as you will be to the registrants that you will serve.
Well, thank you, Tim. Certainly yourself, Sue Galen, and all the staff members here have certainly made me feel very welcome this morning, and I'm very happy to be serving with all of you.
The Chair certainly extends the invitation of any assistance that you may need from myself, and I'm sure it speaks for the other board members. We'll be glad to help you in any way at any time. Okay, the next item will be the election of officers. Our board elects 2 officers. It elects a chair and a vice chairman. So I'll open the floor for nominations for chairman.
Mr. Chairman, I renominate Mr. Tim Lingerfeld.
Other nominations? Is there a second for that nomination?
I second it.
Okay. So we'll close the nomination, and Chair will ask for a vote. All's in favor?
Aye.
Opposed? Okay. Then thank you very much from the Chair. I appreciate your confidence, and I hope I'll do the job that you've asked me to do. Now we'll have election for the Vice Chairman.
I nominate.
Second that nomination. Are there any other nominations? If not, the nominations will close. All those in favor? Aye. Opposed? Okay. Congratulations, Mr. Northcutt.
Thank you very much.
Okay. Okay, now we are to the legal report. Mr. Herndon.
Well, actually, we had 6 come in, we got 6 on it, so we're really keeping up with our complaints. And I'd really like to thank the board for being so diligent on these. I think you got a paper copy. Okay. Does everybody have a paper copy?
Yes, sir.
All right. Under the heading of new cases, number 1, this is case 2013-008771. The complaint alleges the respondent, a licensed surveyor, committed misconduct through misuse of his stamp in violation of rule. Specifically, the respondent submitted documents bearing his seal for a local planning commission's approval, and these documents were rejected because a signature on the seal appeared to have been traced over rather than signed. After the complaint was filed, the parties have resolved the issue, and the complaint has submitted a written request that the complaint be withdrawn, and there's no complaint history with this respondent. I recommend to close the case with the letter of warning to be familiar with all applicable.
Mr. Herndon, if you would, at this time, we have time in our schedule, I would like you to review the disciplinary processes for letters, et cetera, so that we can bring Jay up to speed with the rest of us.
we have what's called informal discipline and we have formal discipline. And informal is any action we take that doesn't affect the respondent's license, in essence, assessing a penalty or suspending or revoking. So the informal consists of letters and graduated degrees of severity. The least severe is a letter of instruction, which is usually reserved for somebody who's fairly new and perhaps made a mistake that apparently is something that they just didn't know about. It wasn't done on purpose or maliciously. Then it moves to a letter of caution, which is whenever we determine that whatever they did was perhaps sloppy or could have been done better but wasn't particularly egregious. A letter of warning is when we suspect that you did know what you were doing, but you did it anyway, but it doesn't rise to the level of misconduct that would necessitate doing something to their license. And I'm having our extern that's here from Belmont Law School, he's doing a research letters of reprimand, which I'm trying to see if we can add a letter of reprimand and whether or not that is formal or informal, to see if we can put that. That would be certainly the most severe letter you could get before we do something to you. After that, it goes to formal discipline, and that can either be assessing a civil penalty or suspending somebody's, revoking somebody's license. And revoking, of course, is absolutely the most severe thing we can do, and it's a last resort because we don't want fewer practitioners, we want more practitioners, but the ones we have, we don't want them to be so incompetent that they're a danger to the public. So, to my knowledge, I don't think we've revoked many people at all. Badly reflects on their ethics or their honesty that we can't tolerate them to have a license with us. Hey, I don't know if we're certainly not doing any revocations today. But by and large, a lot of these cases, as you know, as practitioners, people have different ways of doing things, and if you do arrive at two different conclusions, that doesn't mean either one of them is wrong. It just means they use different complaints we get have to do with that. A lot of complaints all of it, or most of it, unless you have anything you'd like to add.
Thank you very much, Rob, on that. So I want to just kind of get Jay up to speed a little bit and we'll feel a little more comfortable, because I do not want a new member sitting here with us and the rest of us discussing something that's old hat or familiar to us, and you're wondering what we're talking about. No disrespect to you whatsoever. I just want to make sure we're all on the same page.
Any help is well received, and thank you, Rob, for that explanation. That was helpful.
I will say I guess we have officially eliminated one step, the informal step. Has that officially been eliminated when we had the informal hearings?
Yeah, informal conferences, and that's a good point, Chairman. If we get a complaint to where we have questions, or I have questions about, there's things missing, some details about what exactly went on, then we can have an informal conference with the respondent, and that's when we get one board member to come in with me and the director and the respondent to have a discussion and ask some questions about what happened. Of course, that board member has to recuse if it goes any farther than that. We haven't had any of those in quite some time, but those are usually when something has gone afoul between two private parties and we have questions on whether or not it was true incompetence or just a misunderstanding that got out of hand. Hadn't had one of those in a while, though. But that's really kind of an investigative tool rather than a disciplinary thing.
The other thing is, Jay, just a couple things. These complaints that Rob will be bringing before us today have been submitted and processed, investigated, and they have been sent to one of our complaint and they review them based on our statutes and the merits of the case, so forth and so on, and then they make a recommendation back to Rob, and he reviews that and determines whether or not their recommendation is justified or it needs to be expanded upon or whatever. Then he presents it as he's presenting these cases to us now. And then we as a board can do a couple of things. One is we can go with his recommendation, or we can change it and do what our recommendation is or whatever, as long as we have basis for that. Sure. So that's kind of the process that we're in. Expanding one step further on the formal, and we'll have one that we may talk about a little bit further on into this package. On the formal hearing, we will actually have a judge come in here with us, and the department will have an attorney. The respondent has the opportunity to have an attorney also, and we as the board then basically will act as the jury. And the reason for the complaint reviewers is so that we as a board, because we are so few in number, don't have to recuse anybody. Stay intact. I mean, even if a member happens to be absent because of illness or something, that act to be able to function in the formal hearing. Okay. I'm going to turn it back to you, Rob. Thank you very much, Rob.
Recommendation for this first case, even though the complainant has asked to withdraw the complaint, this is another point, the complaint is not the complainants, it's us. Criminal process where it's the state versus the respondent. Even though the person that brings us the complaint, the complainant, they're just the vehicle by which we find out that there might be a possible violation. So even though this person that feels like they were aggrieved wants to withdraw the complaint, it really doesn't belong to them, it belongs to us, which is, I put that in there so you'll know that, but ultimately it's up to the board if they want to close it or not. But in this case, seeing that somebody placed over their signature or allowed somebody else to do it, I think we ought to do something, and we don't want to be arbitrary or capricious about anything we do. We want to be consistent. So I recommend a letter of warning in this particular case because that's something the practitioner should know. Recommendation.
My understanding that you're saying there's precedence on something similar to this in the past with a similar...
Actually, I've never seen a complaint like this. Practitioners should know better than to do something that they know.
We'll entertain a motion to the resolution of this matter.
Well, I make a motion that we take the
Have a second?
I'll second it.
Okay. We have a motion and a second to take the attorney's recommendation to send a letter of warning to the respondent. All those in favor? Aye. Opposed? Okay. Motion passes.
Right, number 2, case 2013-01-0821. Matter was previously presented at the board's meeting, there should be meeting in there, on April 11th as follows. The complaint alleges the respondent and the licensed surveyor committed misconduct or provided surveying services incompetently in preparing a plat. A review of the complaint information shows the complainant is an adjoint. There's no evidence in the file that the respondent's plat was anything other than a professional opinion that did not establish property boundaries, and in a letter the respondent advised the complainant that he should have made a survey for him by another surveyor. Since the respondent was hired to produce a survey by another entity for its property, There's no complaint history for the respondent, and at that time I recommended closing the case for lack of grounds of discipline. If something else, the board agreed with that. All right. In the intervening period, the complainant disputes the board's decision to close this matter and asks the board to reconsider based on new information. This information consists of property information from the city, some documentation associated with the boundary of an allegation of incompetence, and there wasn't before either. This matter seems to be either in litigation to settle the boundary dispute or is headed in that direction. So, this is an example of where we have to hear something twice. The recommendation is to close the case with prejudice, with the option to reconsider only if the results of litigation indicate misconduct on the respondent's part. In my view, that's the only new information we should ever consider, but for our purposes, we need to close this case and it needs to stay closed.
Well, now, is that recommendation different than what you provided to us? I mean, the last thing you just said?
Closing with prejudice means we need to close it and it needs to stay closed, and we're not going to hear it again unless the results of the litigation that come out of the court specifically in that case we can reopen it. But other than that, this needs to be closed.
I want to clarify that. I was sort of hearing you say that, and then Ernest just saying you just wanted it closed, period.
Well, I mean, I think...
And basically, it does that. Basically, it does do that.
But I think if there is litigation and it does turn out that this person did something wrong, then we should do something. But other than that, it needs to stay closed.
Discussion or questions from the board? Seems as though we went through this once, and it comes back, as some of these complaints we have do. They kind of have some rubber about them. They bounce a little bit. Okay, if there's no other discussion, we have a motion.
I make a motion that we close the case with prejudice.
I second it.
Okay, we have a motion and a second. All's in favor? Opposed? Okay.
Number 3, this is 2013-012461. The complaint alleges the respondent, a licensed land surveyor, potentially committed misconduct through conviction of a felony in violation of our rule on misconduct. That's directly on point. Currently, the respondent has been arrested and charged with the felony involving moral turpitude, which is just legalese for dishonesty. There's no complaint history with this respondent. I don't know why that says rule. Recommendation, not ruling. Approved for formal hearing with authority to settle with the consent order for immediate revocation upon conviction, with the provision that if the respondent is acquitted, the complaint will be dismissed.
I understand our statute, a felony's pretty much automatic.
That's grounds for discipline, certainly.
Now, a question that I have, not about this particular case, but in this regard, while we're in the spirit of this, are you or someone in the department notified if a registrant of this board, a mechanism for that?
I'll let Nicole answer that, because
fortunately not always, but in this situation, the TBI notified me.
I just was curious about that. Okay. Well, certainly, this board takes very, very seriously anything that has the word felony involved with it. Very representative of the type of registrants that we would like to encourage. Are there questions, other discussions from the board?
I have a question.
Yes, ma'am.
Do we automatically take his license away, or do you have to have that formal hearing?
Have to have a formal hearing to do it ourselves. If he agrees, basically, if he signs it and sends it back, one of two things will happen after the trial. He's revoked or he's not.
Did you feel like in the reviewer's opinion that the reviewer indicated that the respondent's license should be revoked?
Actually, this didn't go to a reviewer because it was pretty, a question of fact in my mind. He was arrested, charged that is very dishonest. I think warrants a revocation.
Well, let me ask this question then. And I think we're beating around that bush a little bit. Can this board, based on the evidence that you have received and your representation to this board, can this board vote to revoke this respondent's license, and then you do the appropriate letter and so forth, and if they don't agree, then their option by our process would be a formal hearing?
That's what I'm trying to do with this consent order. What you'd do, you'd approve a formal hearing to revoke, but in the interim, settlement offer through a consent order for revocation. Of course, if he's convicted and goes to prison, the hearing, he probably wouldn't show up. It would be a default. As a matter of fact, I was a little questioning the ability to get service to this incarcerated, but if he signs this, and that's what we're doing, is it's just a voluntary revocation on his part without us doing anything. The word wants to happen, I formalize it in the settlement offer. If he signs it, sends it back,
Equally so, I'm concerned that if this individual has been accused and practice what you say that it is, because we don't know, you do, we don't, this individual is continuing to practice up until such time.
I don't think that's the problem. I thought about that, but he's not at liberty to go out and practice right now, and won't be. Otherwise, I would have
Implying
suggested.
he's possibly incarcerated.
I know he's incarcerated. There's no danger of him going out and continuing to practice under these circumstances. Otherwise, I would have recommended a summary suspension, which is a last resort. Recommend it because I don't feel there's a danger of him preparing any plats.
Just so that I understand, as a point of clarity, this individual has been accused and is incarcerated, and basically what we're saying is that or convicted, we're going to revoke your license, and if you want to invoke a formal hearing, we will hear you. That's basically what we're saying.
Convicted, you're revoked
Right.
with this consent order. If you reject the consent order and you're convicted, we're going to have a formal hearing whether you're here or not.
Okay. I don't have a problem with that.
Is this incarceration, or would his incarceration be still incarcerated up to the time we would have a formal hearing? Or do you have any?
No bail, or it's so high that there's no way he can meet it, which means he stays in jail until the trial. After the trial, they let him go, or he goes.
released from jail prior to the trial so that he might go back and start practicing surveying. You don't think?
No bail, they're not going to let him out. And if it's $5
But you
million,
said no bail.
he'd have to cough
That's
up
the only reason I
$500,000 to get out of jail, which is unlikely.
Rob, quick question just to clarify. If the respondent is acquitted, does that basically make the consent order null and void?
Other discussions or questions? If not, I'll call for a question as to the recommendation from this board.
Move to approve item number 3 with the rulings from staff.
Motion is second. All's in favor? Aye. Okay, opposed likewise? Okay.
Or 2013-0129. Surveyor committed misconduct or provided surveying services incompetently in violation of the board's law and rules. The matter involves a disagreement on the location of a property line that seems to be based upon differing opinions of the location of one point. No complaint history for the respondent, who's been licensed since 1986. And since the complaint was filed, the respondent has deceased. So, I recommend.
Have a motion on this?
I'll make the motion. Dismiss it.
Have a second?
I second it.
Those in favor? Opposed? Okay, motion passes.
Right, the next heading, we have 2 cases that have been sent to the complaint reviewer. First one's 2012-011951. The case was referred to a contracted complaint reviewer for analysis because of the allegation of incompetence in the respondent's professional practice of land surveying and possible violation of all these authorities. That's what the complainant alleges. The complaint alleges that the respondent was incompetent in surveying, failed to research common boundaries, failed to notify the complainant of a major discrepancy between the deed description, failed to set the monuments correctly, and later testified in court on the matter in a way that the complainants allege was incorrect. There's no formal complaint history for this respondent. Although after careful examination of all the documentation associated with this matter, the complaint reviewer did not find probable cause that the respondent deviated from the expected standard of care in any manner that demonstrated incompetence, and that the transcript of the court testimony only reflected the respondent's professional conduct. The matter is characterized as a boundary dispute with the judgment of the respondent deviating at some points from the previous surveyor. However, the complaint reviewer identified a possible violation of a board rule that was not cited in the complaint. And this is something we probably need to talk about sometime, because it keeps coming up. Here is about survey types and requirements. A survey map or survey plat shall have a title and a caption, so on and so forth. And then it gets down here to where it says, ratio of precision of the unadjusted survey. Survey does not meet the standards of certification because the ratio of precision of the unadjusted is highly unlikely. And this comes, apparently, surveyors are putting 1 to 7,500 on their surveys, which is
But I think that statute reads, and I'll pull it out here, but I think it reads that it should be, that is the minimum required for that particular type of survey.
apparently this designation keeps showing up on surveys. The recommendation is to close the case with the option to reconsider should new relevant information be discovered.
Bob, it sounds like on this particular case, again, it sounds like this is, according to the reviewer, a matter of a boundary dispute.
Said earlier, two surveyors can come to two different conclusions, but if they use proper methods, they haven't done anything wrong. And that's what happened here, but of course it just really grates people and landowners when that happens. I'm sure you're all familiar with that phenomenon.
One of the things, that is in our statute, surveys, and obviously the one that says 1 to 7,500, that's suburban. And someone survey that this, the ratio precision meets or exceeds a 1 to 7,500. He hasn't said that it is exactly 1 to 7,500. He just says that it may exceed that. And maybe we ought to statement on there, don't say it's 1 in 7,500, that it meets or exceeds that kind of.
And I guess it's just a matter of how you feel about it. It is supposed to be it, So, literal translation of the rule, which says ratio precision of the range of precision. It says ratio of precision, which I guess is what the reviewer is trying to point out.
And we don't know exactly how the respondent worded that statement on their document.
I think it's in a little chart that says ratio, and it has them described as being.
Not seeing exactly how they worded it. It's a little hard to, other than do what Galen's talking about, just speak of it in general. This bodes itself, as far as I'm concerned, for a good topic the next time we have a meeting with the surveyors. We gave them the intro this time. Maybe next time we can talk about specific topics, like things of this nature.
Attracted the board's attention through its agents, so don't want it to cause confusion or, spread hate and discontent among the populace if we can avoid it.
Well, and this time when we approved the new minimum standards of practice, there was not a blue book printed and sent out. So, a lot of the registrants are looking at it on the website and so forth, and statute is what it is. Just like when we see a statute, there's reference cases and things of that nature. Well, you got to go find that case to see what it's really trying to tell you. Well, unfortunately, in our standards, we don't have a little dialogue from the board to say, this is kind of what we was thinking, or this is what we feel that this should say to you, or how you should imply it, to what your work is. So that's the unfortunate part. So that's part of what I'm looking at with our board communications and stuff with the registrants, to try to help pass on what our thoughts are about certain parts of things that we always are getting questions on.
Some of the reviewers think it's unlikely that you can draw a line through many miles of wild and hostile country and not deviate 1 inch between 2 points. Maybe you should bring that up at one of the next association meetings or something about how the board expects it to be interpreted. So the recommendation, I'm not really going to suggest we do anything to this person.
Second? Okay, we have a motion and a second. All's in favor? Aye. Opposed? Okay, I think we're down to the last one.
Oh, 13001. In this case was referred to a contracted complaint reviewer for analysis because of the allegation of misconduct. A possible violation of our applicable rule. Alleges the respondent and the licensed surveyor committed misconduct or provided services incompetently by creating a question about a property boundary that is quote-unquote common knowledge, according to the complainant landowner. A review of the complaint materials does not reveal any public statement being made. Clarification of the cited rule is making a public statement, and this board has interpreted that to be public statement made on a transcript, of which there is none in this case. A review of complaint materials does not reveal any public statement being made in the context contemplated by the cited rule. However, the complaint reviewer was charged with examining the documentation for any other possible violation of the board's authorities. Ultimately, the matter involves a disagreement on the location of a property line that seems to be based upon differing opinions of the location of one point between two surveyors and landowners. From this, you would be correct in, I guess, inferring that this is the other surveyor. Once again, this particular reviewer is pointing out that the ratio probably isn't correct. As the surveyor was conducted with GPS equipment, so closure by conventional survey equipment is not available. I recommend close this case as well, because we didn't find anything wrong with it.
I would like to speak to the statement about the closure of GPS versus conventional equipment. I realize that GPS brings a closure that is somewhat astronomical in relation to the minimum closures that we have for. However, when we did the minimum standards, but in those standards, language that specifies if the survey is done with GPS methods as to what is to be placed on that survey. And this statement tells me that that information was probably not placed on that survey. So I have a problem with us passing on that, because my recommendation would be that the case reviewer relook at that survey in regard to the new standard. Make sure that this respondent has met the standards that are required, because basically it's my opinion when we crafted that yes, GPS is a very technical tool that we use to same token, the product of that work must still meet the minimum standard. Is the information that's necessary for the respondent to place on their work product, so that the next surveyor, whether it be me or Galen or Jay, can pick up that document and understand what datum they used and so forth and so on, all the basic criteria of the items that they used to create that survey, so that if we have to recreate something that's on that survey, we are recreating it in a method, in a manner that they used. Right. So we get back to the same place. I totally disagree with that statement, because I think that there's relevance when you use either GPS as the sole source for your doing a boundary, or whether you use GPS as an part of doing the boundary, along with conventional methods. I think that there's language and a way to do that, and I think that our standards basically speak to that. So my thought on this particular case here is that particular item, I think, should be re-reviewed.
Or ascertains that all the standards were met. It's back to me that the standards are met. We close the case. If he does find a problem with it,
Right.
then we'll look at that. Okay.
Because just as we discussed when we had the public hearing relative to GPS, we had no standards at all in the prior minimum standards about GPS. Yet GPS had been working at that time for close to 20 years. So the statement was made, and I think you made the statement, that if we had a complaint relative to a GPS survey, we had no standard to base our justification of whether it was done correctly or incorrectly. So therefore, we created standards, put them in the minimum standards, and this is just one of the first ones that we've seen. Certainly would like to know that the respondent has complied with what the new standards are asking them to do.
Statement of the recommendation, which would be to close with the option to reconsider if new information is covered, which is what we would do if we find that there's a deviation.
At the same token, we're asking the case reviewer to re-review it.
I'm going to write, re-review for compliance with promulgated standards, close if no violation is found. A little more detailed than the recommendation that was put out there.
If the reviewer finds that there is no documentation on the registrant's plat, then what?
Contact the respondent and try to find out exactly how this was produced. Notes, we can find out as much as we can find out.
I don't want the members to misunderstand. I'm not on a witch hunt here by any means. I'm just simply saying we have a standard. Did the respondent apply the standard? If he did, wonderful. Not, then it sounds to me as though there's a letter that needs to be
Authorize that then?
And I agree with it, because I think that's exactly where we're headed. I think that in this particular case, we don't know whether that statement was on his plat or not. In all likelihood, it probably was not, and the reviewer didn't, catch this. So maybe the letter should go out to the respondent that states, you need, with caution, you need to review your standards, and if you need to put a statement on there, with remote sensing or whatever it may be, be aware that we don't know it was on there, but you need to be aware that you should put that on there if you're using that in conjunction with equipment, or if you're using that only as your basis to do the boundary. Having a reviewer, let him re-review the thing and say, hey, did you see this? Just caution when you review this thing, because if GPS comes up in this thing, then there ought to be a statement on there, on that plat, that says our standards say equipment was used to whatever the statement should be. What do you think?
Caution no matter what, then.
I think that might be appropriate and might save some time and what have you.
All standards must be met regardless of
I think you're right, but I think we need to know first, back at the reviewer, that there isn't a statement on there to begin with.
Well,
And that's the caveat here. You know, if there is a statement and it covers the minimum standards, then we're fine. No letter needs to be issued. Everything.
I have had, and I know Donna has too, I've had several questions since the new standards went in regards to correlates or interrelates with conventional and so forth.
Yeah.
And I know that's a question that the registrants across the state have, because I've answered several of them.
Have him take a look at it again, close it, no action, everything's complied with. If he sees a mistake, then a caution letter.
I'd like to make that in the form of a motion.
I knew you were going to definitely do that.
Since you cracked it down.
As amended by staff.
And the motion as amended by staff is that a letter of caution be issued to the respondent if the case reviewer determines that applicable statements concerning remote sensing were not located on the plat.
Motion.
Second that.
We have a second. Any further discussion? All's in favor? Aye. Okay.
For the legal report.
Here's our legal report, and we'll come back to a couple of those questions that you were talking about a little bit later, Rob, because you'll be here. The chair would like to apologize for not recognizing our new representative with us today from the Tennessee Association of Professional Surveyors, Mr. Leonard Tussar. Leonard, we'd like to thank you for being here. We'd like you to extend to the organization the board's appreciation for having a representative from the association here. We certainly appreciate that, and if you have anything at this point in time that you would like to say to the board or address the board on, we'd be glad to hear it. Okay, thank you. Okay. It's now 10 o'clock, and we have a scheduled applicant conference. Is it the board's pleasure to continue or to take a 5-minute recess?
Let's take 5.
Okay, we're going to take a 5-minute recess and reconvene here in about 5 minutes, and then we'll have the applicant conference. We even have a door. Okay, it is now 10:16. We'll reconvene. We have a applicant conference scheduled. I'd like to ask if Mr. Elliott is in the room, if he would please come to the podium. Mr. Elliott, first of all, the chair would like to extend our appreciation for you being patient and allowing us not to be exact on the exact minute. I understand you have something that you would like to discuss with the board, so we will entertain what you've brought to us.
Mr. Messer said I made a 68 on the test, and I feel like he took off points where he shouldn't have took off, that I got the answer correct. And I would like to get those 2 points. There's about 3 questions that I feel I answered correctly, that he says, on his opinion, I didn't answer them correctly. He said on my scope of work I did a great job, except when I priced it, I put it down as field work and office work. He said that was too broad, so he took 2 points off. I disagree with that. The application to take the test breaks it down to office work and field work and research. But this day and time, you do most of your research on the computer if the courthouse has them scanned in and you can pull them up. So I clarified that as office work. And he took those 2 points off. And then on the multiple choice question, I put my answer down that it went against the Tennessee Code annotated. And according to Tennessee Code annotated, it don't include subdivision as a 5-acre lot or more in their meeting. So that's the answer I put. And Chattanooga's subdivision regulations said it don't include a subdivision of 5 acres and more. And their authority is based on Tennessee Code annotated, my fault, numbers 133401 through 133411. 133402 states, subdivision does not include any division of any tract or parcel of land into 2 or more tracts or parcels when such parts or parcels are 5 acres or larger in size. You do not take it from the planning commission if you add new streets or utilities. They have to review it. Any subdivision into 2 acres, 2 lots, can be signed off by the secretary of the planning commission. So I disagree that I got that question wrong. I'm pretty sure on my legal description I put down more than 6 things that were wrong with it. He said there were 6 major things. I answered 4 of them. He took off 4 points for that. The question didn't say give the answer to 6 major things. It says tell what you feel is wrong with the legal description. I put everything that I saw when I read through it. I'm pretty sure I put more than 6 things, but he took off 4 points for that. And those are my 3 questions that I have the problem with that he took off points for. That failed me when I only needed 2 points to pass.
Well, first off, I appreciate you coming to speak to us about it, Mr. Elliott. Several things. Number one, this board employs Mr. Messier to write it. This board meets with Mr. Messier on a pretty regular basis to review the examination, question by question. It's been less than a year that Mr. Northcutt and I personally did that with Mr. Messier. More than likely, the examination that you took was probably the examination that we reviewed. This board gives Mr. Messier some latitude in discussing with applicants, if they fail the examination, areas of where they were unsuccessful that may have caused them to not. In your instance, Mr. Messier called me and we spoke about it, and he has also sent to me and the members of the board at my request all the emails that you sent back and forth to Mr. Messier. I personally find the aggressive nature that you approached it with, I understand your certain concern, totally unnecessary. I find that Mr. Messier went beyond what the board is comfortable with in discussing issues and things with the applicant. I see satisfaction from you in those emails. I think there was some 17 of them. That's, again, in my opinion, it's excessive. I review your record, and I see that since '05, you have taken this particular examination 7 times. I have concern about that.
I think I've only took it five times. One time I didn't take it when I showed up and took the national test.
I'm looking at your record directly in front of me, and the record that I have says 7 times, and I will quote that you took it in April of '05, October of '05, April of '06, October of '06, April of '07, October of '12, and April of '13. So that's what the board's records indicate, that you've taken the examination. I want to tell you one thing emphatically, and the members can speak to you individually, their own mind about the situation, but I have the utmost confidence in Mr. Messier, in his ability to do the things that this board and this department contracts him to do. And very, very, very rare instance over the last 15 years that we have had individuals such as yourself come before us to discuss specific items about the examination, their displeasure because they, and generally they've always been because they've not passed the examination. But they've continued in their process and either passed it or did something different. But I certainly want to indicate to you from me personally that I'm not pleased in the manner that you approached this. I think you did it correct by coming to speak to the board, but I'm not pleased with how you handled it, Mr. Messier. I think that, just as you said, certain things are excluded from TCA relative to subdivision. You didn't misspeak, but you convoluted all the items that you spoke about. So as far as what is a subdivision, what is not a subdivision. So, I have concern about that in what you've said, and I'm basically going to stop at this point and let any of the other members address you, either in any statement or by question.
I wasn't trying to be ill with him. I even told him I respected the review seminar and everything that he does, and I appreciate it. I went to it, and, I got a lot of great information from it. That helped me. But, my understanding as a subdivision is what the Tennessee Code annotated and what the Planning Commission is authorized to do from the Tennessee Code annotated. So I felt like that was the best answer. And I emailed him and said that they usually don't review a subdivision if it's 5 acres or greater. And the question asked, when the Planning Commission reviews a 5-acre tract, which is the answer, which that answer was not on there. The only one I saw suitable that was on there was it went against the Tennessee Code annotated. But I wasn't trying to be ill with him. If I'd talk to him, I'd talk to him just like I'm talking to you. I know typing out my questions and discern may have sounded ill because I was typing it out and he couldn't see my expression or my, body demeanor. But I wasn't trying to be ill with him. I was just trying to get my point across. I felt like, so I've got bills from attorneys. They don't itemize. They just send you a bill. I've worked for multiple surveying companies. When they send their bill out, they don't itemize it unless a client specifically wants it itemized. And what I itemized in my scope of work was everything that I had to do to do that survey, which all those items broke down into field work and office work. But he said it was all, and he took the 2 points off. I've been 20 years. I take pride in what I do.
I'll take that for a minute there. Mr. Elliott, I'm not really familiar with the entire case other than what I have here in front of me, which in some ways may be a good thing, is a positive thing. So all I have here is what's on the surface based on the chain of emails that you had back and forth with Mr. Messier, as well as your past testing history here with the state. I got to say that just on the surface, while I admire your persistence in continuing your efforts to pass the Tennessee specifics of surveying, I'm a little discouraged at the continual results here. That while you do show progressive better scores, the fact is that this is a 2-hour exam where you're requested to pass just the minimum scoring, I believe, of 70, if I recall correctly, which, after what the record shows here 7 times, has not been attained. So that's a bit discouraging, to be quite honest with you, especially from a professional like yourself who says he's been surveying for 20 years. So it's a little disconcerting. Second issue I have here is this, is the chain of emails here. It was, I think, Tim, I think you used the word aggressive. I would concur with that. It just, again, just, you can't read emotion into emails, and I understand that. The second thing on the chain of emails, Mr. Messier did spend quite a bit of time, probably above and beyond what I would ever expect him to, in explaining the score that you obtained in terms of the questions that were missed, how many points were missed, what was missed, etc. My suggestion, this is my personal suggestion to you, would be, if you are the professional that you said you are, and I'm not disputing you, then come back here the next time you're available for this exam and score better than 70. It's as simple as that. And that's not anything that's requested of any other potential surveyor in the state of Tennessee. So that's what I'm requesting.
I felt like I did score above 70.
I understand.
Elliot, I have to concur both. Frankly, whatever the questions were on that exam, if they ask for a specific behind that was to give the very best answer for that particular question, whether it was in Tennessee Codes annotated or whether it was not. If he was asking a particular question, the test exam was to see, do you know in general everything that we're going to be going through as a surveyor? Whether it shows up in Tennessee Codes annotated or whether it just shows up out and covers a wide scope of things, but generally stays within what is within the laws of the state of Tennessee. So what the question was, give the very best answer that you can give on this. The effective answer, and you've got to give it, and if you didn't cover, you mentioned the 6 items for a particular thing, you may have covered 8 or 10 items. 4 of the 6 items that he specifically was looking for, you didn't cover it. And so my opinion, again, 20 years of surveying experience should come to play here and say, okay, I can think like a surveyor, I can do like a surveyor, I can be a surveyor. By yourself and look at all these things, and if there's another question concerning the exam after it's over with, I'm going to suggest that maybe you our contractor. He's not yours, and so we prefer.
Notified Donna, and she said I had to call him before I could speak to the board. So
that's
I
correct.
emailed
That
him.
is our procedure. She told you the correct procedure, yet that procedure got out of hand, in my opinion.
Yeah, I think so.
I understand, I appreciate your aggressiveness, as Jay said, but, I kind of look at an examination like a baseball game. There's a lot of things that happen between the first and the 9th inning. And if you're the last batter in the 9th inning and you strike out, did you lose the game? A lot of things happen along the way. So if you scored less than the minimum score and you're focused on 2 problems, there was bound to be some other problems that you didn't get correct. So having said that, the focus in one narrow area doesn't carry a lot of weight because there was more than one narrow area, even though that narrow area allowed you to maybe get over the hump or the minimum. So there's more there than just to beat one little thing.
I felt like I got at least one of the hydraulic questions right. He said he counted off because he didn't see my work. I didn't show my work. But I felt like on the chart and the graph, it was a 27-inch, I stayed below the minimum.
Anytime, just for what it's worth, anytime you take an examination that's paper and pencil, and it has type of essay, opinion, problems, things of that nature, showing work is critical because just as Jay said very properly in reviewing your emails, that's all he had to look at about the situation. It's the same thing for the person that's scoring the examination. That's all they have to look at. They can't read your mind. So if it's on paper, they got a better chance of saying, well, this is the process that person was going through.
On the first hydrology, when I did write out the numbers and stuff on the side, I might not have, put the plus and subtract the figuring out the thing, but, felt like I did show some of the work, but he counted off for not showing it, so that's fine. I wasn't arguing that.
Well,
I just felt like my scope of work and everything was.
I don't think we need a motion, but I think from the spirit of what I've heard from the board, I think that the board desires to stand behind Mr. Mezier's results and also encourages you to reapply and strongly apply yourself to the next examination that you take.
I think you can get through it, but, just apply yourself.
And I know I can get through it. I work on $84 million jobs and do all the computations and layout. I don't think I have a problem getting through it.
Well, thank you very much for your time, and if you have anything else.
Thanks for having me.
Okay. Because of having our appointment here with Mr. Elliott, we skipped over our director's report, so we're going to back up in our agenda to the director's report. You have it on the iPad and also in paper form before you, so I'm going to turn that over to Miss Donna.
Well, we have a new board member, Jay Kaufman. Jay's filling David's vacated spot, and he'll represent West Tennessee through June 30th, 2019. So, welcome, Jay. And next thing is we need to schedule board meetings for 2014.
When we look at our board meeting schedule, for example, in 2013 we met 1st of February, basically 1st of April, 1st of August, and last of October. Or I think that's right.
October 24th.
So that's been our cycle. We pretty well met quarterly, but now the consideration we need to put in now is the FS exam because it's going to be computer-based. And I think from our last meeting, if I recall correctly, we decided that we still want to review all applications for the FS exam.
Yes.
And in doing so, we don't necessarily want to hold anybody up, which means that we'll need to review applications at each meeting for the FS. Still, we'll have to review in 2014 the PSTS applications on the regular schedule that we have in the past, because NCAAS will still be giving the PS in April and in October. So, two factors to consider in our meeting schedule. Also, with that, you have a sheet of paper in front of you that has some information about the FS exam. This is kind of how some of the other states are addressing this, and this is something that Donna is going to need to put on the website so that the applicants will understand what's going to happen and what the procedure is for the FS exam, since it's now going to be computer-based. So we need to make a decision today about how we're going to handle the FS exams and in conjunction with our schedule for our meetings for 2014, so that Donna can get on the website as soon as possible, because folks that are going to be wanting to take The FS in January will have to have their application approved in October. Now, for Jay's benefit, NCAAS, and I know you're aware of it, is going computer-based for the FS exam.
That's right.
And they are going to test on a 2-month on window and a 1-month off window.
That's right.
So we've got to be able to hit this so that we can keep our folks moving along, taking the exam. And that's what we're trying to accomplish. So I guess, let's look at our calendar for next year. Deadlines, Donna, for the PS will be January 15, and July 15? Okay. Do we want to meet on January 30 and 31? And like I said, we can put these down tentative, and then we can jockey them here as we see.
You said the 15th of January was the deadline for the applications?
For the PSTS. And 131. We'll look at that for our first meeting. Like I say, we can adjust these here in a minute once we get through this thing.
Sounds all right to me.
Because they have to register NCAAS by March 1, is that correct?
I don't know what the date will be for that.
I
It's
think
June 17th for this one.
it's what?
It's June 17th through September 5th for this one,
Mm-hmm.
the October exam. So they'll probably open registration up sometime middle or end of December.
Are you?
Huh?
I was going to say, is there any way you can double check that to make sure the registration window? Because we need to make sure we perform so that they have ample time within the registration window. And that's been our standard of, last week, January, first week, February, to make sure we were good for FSPS. Well, now FS is out of the window.
For the April exams last time, they had to be registered by, I guess I can call double NCAAS and ask them.
I think it is the middle of February, if I'm not badly mistaken, which if we get it done the last week of January, you'll notify them the first of the following week.
We'll meet the 30th and 31st, and then starting that Monday, I'll start notifying.
Probably give them 2 weeks to register. So if we, October of this year for the FS, and the other thing on the FS, we're going to be approving, and I don't know if we need to speak to this or not, but when we approve an FS application, it's going to allow them a 12-month window from the time they take their first examination. This is NCAAS language. Whereas if we approve them in October and they don't take their first exam until April, they have a 1-year window with NCAAS to take it, and they can take it up to 3 times. 1 time in a window, 3 times in 12 months. So like I say, we need to make sure that we concur with that scenario, because we're not going to see that application back to us unless after the 12-month window they have been unsuccessful or have not attempted.
Right. Over, now, of course, we'll meet here for the hearing, but
October, we would review FS applications, which would put them in the system. If they wanted to start January 2 and take the exam, they could. anytime thereafter. Speaking of which, you make a good point, Galen, and thank you very much for doing that. We have a public hearing currently scheduled for the October meeting for our continuing education chapter. I would like to suggest, just as a suggestion, if we have the public hearing on Thursday of that week, I'd like to suggest that the board meets on Wednesday and then meet on Friday, leaving that open. And the reason I'm making that suggestion is because the potential looms that we'll have a second public hearing at that same meeting for the rules of conduct, because they're right on the cusp of being available for that. And Rob will know that sometime within the next probably less than 30 days, hopefully.
So it'll be a 3
Be a 3-day meeting, and that way that would ensure us of being able to do board business, do a public hearing, and review applications. And like I say, applications is something we normally don't do in the October meeting.
and probably 2 public hearings.
Could be 2 public hearings. And if we did have 2 public hearings, we could schedule one on Wednesday, one on Thursday, and then do board business after the public hearing. And if we don't get that done, finish on Friday. I'll give you something to
Certainly
do.
haven't had an influx of applications.
No. Well, that'll give you something to do at lunch while we're eating.
Right.
Well, obviously, if we don't have the second public hearing, then 2 days is all we need for the meeting anyway. But if we had the second public hearing that came up,
Robert can just talk faster.
Well, we've sent these chapters through TAPS and everything, hopefully to get all the comments that we're going to get, and there won't be much public. I really want to get both these chapters done.
These are biggies.
so do we.
Yeah, we do too.
But anyway, if it's available, it might be the best thing to do. If this second public hearing comes about, I'm with Tim. So we consider, tentatively, we'll consider Wednesday through Friday.
Probably just cut it down to the bare minimum so that the agenda just flows. Possible, so that the meeting doesn't run any longer than it needs to for you guys.
Well, and as Rob and I discussed earlier this morning, we were just looking about some separation between the 2 public hearings so that they weren't necessarily back to back. One was I get a little separation because you may have different individuals that want to speak about totally different things. Be some of the same people and maybe different people. So. Do look into that, please, Ms. Nicole, if you would, about the room and stuff, just to make sure that if this falls in place, then we can react to it.
That's why we're looking at 2014 almost a year in advance. Not just regulatory boards, it's all of commerce and insurance, and even some commerce and insurance. Now that we have these fancy new meeting rooms, a lot of people are trying to book these rooms. So it really sometimes comes down.
Okay, let's move on to our second meeting. March is a dead month for FS, so I do note that the TAPS meeting is the 20th through the 22nd. It's a little later than normal. The first weekend of April is out, and the reason I say it's out is because on the 6th and the 8th, they have the Women's Final Four in Nashville. So I don't think we're going to get any rooms at all, 3rd and 4th.
April the who, 3rd and 4th?
Yeah.
Third and fourth, or
Huh? Do what, Donna?
is it the third and fourth of April, or 6th through the 8th?
Well, the 6th and the 8th is when they actually play. They play on Sunday and Tuesday, but there'll be people in here before for the Final Four. Typically, we've been meeting on the same week as the exam. So, what do you think about 10th and 11th of April?
Wouldn't be the first time. That's all right with me.
Okay. I would also, in April, there's a Southern Zone meeting in Charleston, South Carolina, too. April exam, we're approving it in February,
Okay,
or January, actually. We approved that one in January. But at the April meeting, we will continue to approve FS applications. Yeah. The next,
FS applications
every
meeting.
time.
Okay,
Every time, and that's part of what we need to put on the website.
right.
Next normal meeting would be in August. We usually have a pretty good window. NCAAS is the last, near the end of the month. July 31st and August 1st.
That'd give you enough time, wouldn't it, Donna?
Well, it gives her
Wait.
2 weeks to have them ready for us and 2 weeks for the applicants to do their thing.
Yeah. All right, so 31st and 1st.
Yeah.
All right.
October, we usually do it the exam week, which would be the 23rd and the 24th. Proving the FS exams every time, we shouldn't hold anybody back from being able to take it. Effectively, we'd be approving about every 3 months. Good, because I think we discussed it last time, Donna, that we only had like, 20-some FS examinees in a year?
October of 2011, we had 10 FS examinees. October 12, we had 11, and April of 13, we had 6. A slew of them.
We're not going to have many applications potentially at any given time for that. Okay, so let's review this and see where we're at then. What I've written down is the meetings for 2014 are as follows: January 30 and 31, April 10, April 11,
Right.
July 31st, August 1st, October 23rd, and October 24th.
That's what I got.
Comfortable with that? Okay. Okay. Now have a board meeting scheduled, Miss Donna. We'll let you continue with your report.
Okay. And y'all probably already done this because I probably did it for you, but just a reminder, if you're not getting the emails already, to go to the board's website and confirm that I signed y'all up and Jay signed up, so. Balance that year was $296,000. So far, through June 2013, our FY 2012-13 budget information is 107. Is 116,400. Revenue thus far is $38,969.
'30th. Okay.
July 1 to June 30.
Okay.
And last but not least, our land surveyors activity report as of July 30.
That concludes your report?
That concludes my.
Okay. Well, thank you very much. I would like to say to the members that with the new C environment with NCWS, we will see a change. We'll only get the application monies for all other monies will be handled at the testing center, which is a Pearson View Testing Center, with that money in, that money out will be disappearing from our budget for next, starting in January. We anticipate, NCWS highly anticipates sometime in 2000 having the PS exam, and we're currently working on that, going to CBT also. NCWS arm of how we test folks is going to change completely, and that revenue stream is also going to change on the PS exam. So over the next 2 to 3 fiscal years, budgets, that amount of money is going to begin changing. It will probably reasonably decrease. So as we have been talking, Rob and I discussed it this morning, I think there's a good possibility that the assistant director may help us in getting some type of staggered renewal or something such that it's more of a the commissioner, such that it's more of a continual revenue stream as the current feast and famine that we go through, because we renew every odd year. I really feel like that with the changes in the revenue and expenditures with NCWS, that would be a tremendous plus to us, and we would be able to better review, because we don't act better review to ensure that this board stays in the black. Whatever it may be, but I think it'll give us, by getting on some type of rotating basis with the licensing fees, it'll get us back to where we can actually analyze that budget better and know that we're staying where we need to be, above the Mendoza line.
Would it be beneficial if this really would even out the budget, and eat feast or famine, and it's been that way for years and years. But
Commissioner is a member of all boards and has the authority to adjust license renewals under a different body of law. I don't have the book with me, but that's one of his authorities, and that's certainly something that he's considering right now, is spreading out the renewals to where everybody just doesn't expire at the same time. It's really kind of feels about it, but there's people that get a license and almost immediately expire, don't they? If everybody expired. Yeah.
They take the exam in October and pass it. They're not notified. Ones that really get a short license are the ones that get their license after the April exam. Like the ones that just got their license, they only have like 6 months.
maybe if we sit down and, of course,
I
with
wish
computer-based testing coming up,
it was from date of issuance. Yeah.
License 2 years later, on the anniversary, you expire, you renew.
I just went to that after the new law went into effect. The ones that were registered prior to the new law still had their same registration dates. Oh, just law changed.
Yeah, the engineers changed their statute. Put in a request that we change our statute to that, but it didn't get into the governor's package because lots can get in the governor's package, and for us, I put in like 5 requests. The rest of them got taken, taking away the 10-year thing. Have to change our statute because of the character of the exam changing. The assistant commissioner feels that he has the authority to adjust our renewals without us having to put that in the package because there's only so many slots, and I'll talk to him about it, about what his plan might be for that. Wasn't enough room to get that in the wish list
So
this year.
just as you recall, just last March in the TAPS meeting, one of the questions is, and it's a common question throughout the state with our registrants, is our board going to be asked at the meeting? I mean, that question is asked hundreds of times every year. There's that much concern for the registrants that they appreciate the independence of their board, and they want to make sure that nothing happens to change that. And I think this is a step in the right direction so that we do have a little better control.
Talking like they're trying to merge those boards.
Oh, no, but it's
haven't either.
a very
Always
common
comes up.
question. Yeah.
There's lots of boards that have resisted combining, like barber and cosmetology, which are 2 separate boards, and none of that's ever gone anywhere. Combining boards hasn't really gone anywhere.
I had a terrible time getting my hair this morning.
I haven't heard. I've never heard any interest in either board
Being
or
combined.
either industry in combining. So it's
Registrants or the government, neither.
it's
Okay.
the same other states, isn't it?
Lucky theirs is combined, and I guess,
Majority of them are combined.
yeah, a lot of them
There's
are
only
combined.
16 in the United States that are
Independent.
separate as far as surveyors go.
Ours is A&E board, it's already a super board. It already regulates 4 different professions. They have architects, engineers, landscape architects, and interior designers. So grafting surveyors would make 5 regulated professions under one board. So I think there's probably a lack of interest in doing that, just from the monolith.
Wait, Donna, we need to, I promised John Cothran that when we got our dates, the reason I say that is if we want to tweak one of them because we were unable to have a joint meeting. Their dates, if we had to move one a week or something, as long as it doesn't affect our exam application process, I'd like to do that. I know Galen and Jay would probably like to meet with them too. When we went upstairs this morning. Work on a different timeline.
Just getting in the office right now, I think.
Yeah.
Work on Honduras time.
Yeah. Okay. Looks like that the next item on the agenda is a TAPS report, a report from the professional organization. So I guess, Leonard, do you have anything that you would like to report?
Well, actually, I don't.
Okay.
I haven't been in touch with the president. I've had a little bit of transition myself and have got to notify Donna of a change of address. So I've been a little bit out of sync with what's going on. I mean, I have attended chapter meetings and what have you. I was hoping that the president would have sent you a written report or a written something, Mr. Mormon. So, okay, well, I will remind him that would help, or I will have something to report at the next meeting.
And we do appreciate you being here and look forward to a very positive.
Well, one of the things that was discussed at the last Surveyors Board of Directors meeting is that the assignment of attending the registration board meetings was assigned to the middle director at large, of which I am. I was not at that meeting. I was unfortunately out of state at that time, but that was a task that was assigned to the middle director at large, and specifically, to handle that with the ability to call on other people as necessary to be here. So, but able to attend and then have some input where necessary.
Okay, next item on the agenda will be the NCEES annual meeting. The meeting is this month. It's the 20th to the 24th in Antonio, Texas. I have been informed that this board needs to, I guess, prove the fact that Mr. Northcutt and I are going to the meeting. Since we've all the arrangements have already been made. In the future, we will have an approval before the arrangements are made. But
You have to vote on, in the future, you have to vote on who's going.
Chair would entertain a motion that Mr. Northcutt and I could go to San Antonio, represent the board.
So moved.
And we need a second to that. Okay. Motion and second, all's in favor? Okay. Good, thank you very much. So we have taken care of that. Like I say, in the future, for example, We have an April meeting, a Southern Zone meeting, that is in Charleston, South Carolina. We will try our best to address that in January so that Donna knows who the board has recommended, and she can begin the appropriate travel arrangements and so forth.
So when is that meeting again, if you don't mind?
The annual meeting?
No, the one that you just
The
voted
one I just spoke to?
attend.
It's April, what day was it in April? It's on the calendar here. April 24, 25, and 26 in Charleston, South Carolina.
And the one that you and Mr. Northcutt will be attending this
No,
month?
sir, the one we're attending is in San Antonio, Texas, and it is in August, the 20th through the 24th. That's this year. Sir. Right along. Looks like the next item of business is to discuss the NCAAS contract.
Talked to you a little bit about it earlier, about, we have at the, one more FS exam before testing for the fundamentals exam. So the idea is that after, we're going to have like a bridge contract to the end of this year. And then after January, we're not going to have a contract with NCAAS for the fundamentals. Because our law says we have to use them, it would be illegal for us to use anybody else, and we could use somebody else, we couldn't grant a license under the statute, so we don't need a contract. So that will that'll go away, and then the same thing will happen after the principals goes to computer-based. Not going to handle money anymore because they're going to go to the test site, directly pay it. So there's no need for us to have any contractual relationship with NCAAS once everything is computer-based. Talked extensively with our contract coordinator about this, because engineers are in the same boat, and we just don't feel like if there's no need for a contract, we just shouldn't have one with them. So they're going to do what they do anyway. Our contract basically said, administer the exam, report the scores. I think that's just pretty much what we've all agreed for in the department. I'm just sort of notifying the board that that's sort of what we're trying. Comments on that?
We're certainly hoping that with this new, quote, new relationship, that it will free up the possibility of NCAA.
Have any perceived conflict of interest? Our board pays NCAAS dues to be a member, so it's not giving us anything. It's something we sort of have paid for as a service. And Donna's going to look into the...
A quick question. Obviously, every other state is having to basically go through the same routine here.
Oh, and I've got that here. Not here, but I've got it. Some of them are doing contracts, some of them are doing letters of agreement. Les told him everybody's doing something different.
That depends on state law.
Yeah.
As to what they have in the law. And if I'm incorporated in the law, I'm like you, I don't see any reason for a contract.
have any choice. We have to use them. And I guess some states have not adopted the model law that we have, required to. And then you have some other jurisdictions like Puerto Rico and some others that are not. As far as we're concerned, there's no need for us to have it. One for our state exam, but nothing for.
WS is actually encouraging, and Galen was at the meeting with me, they're encouraging that the states go to computer-based testing. Well,
due to our contract with the.
let me say this about the situation with our exam and Mr. Messier is Messier came on board as the board at that time sat down and gave him a charge, and I don't know, Sue may have been on at that time, but they gave him a charge of structure for the examination. And a year ago, when Galen and I sat down with him, he basically brought us up historically with how he got to where he is and what he uses. So he asked at that time, Galen and I, if we wanted to change the exam. And I think the conclusion was that we were going to sort of stay pat. But that doesn't mean that at any time in the future we can't, restructure and change that. What the difference here is there are at least, I think, 2 problems that's on the examination require a significant amount of paper and pencil work applicant to do and have some essay merit to it that gives, Mr. Messier some opinion in how he scores that based on certain criteria. Now, if we did go, that type of question pretty much goes away. It's not necessarily eliminated, but it pretty much goes away just because of whatever the limitations are of the computer that you're taking the examination on. Also, before we'd ever get to that step, it also would create a potential hardship on Donna's office because it may have to be given, for example, here, someplace. A lot of other factors that go with that. And it also means, too, that, currently our exam question bank is very small because of the type of exam that it is. And to go to a computer-based exam, the bank of questions has to become maybe something that this board may wants to look into in the future is, possible. Certainly can do that.
Tomorrow, though.
No, it won't be tomorrow. That's a whole other animal.
I will say that our relationship with Peter has been contractor to handle the exam, and when I've gone to the exam, great job for us as a contractor, I think. Hope that Mr. Elliott applies himself this next time, but be that as it
Is there a limit on how many times you can take the exam?
4 times in a 2-year window is the rule that we've been using.
Because for some professions, like for the bar exam, if you take it more than twice, you have to get permission. you have to study under a licensed attorney before you can prove to the board that you're able to take it again.
Wasn't it that way when the surveyors took the exam? They took
Failed it 2 or more times, then you had to come in and meet with the board. I decided to do that retake request form instead of having all the surveyors come in here. Board would review that and then either approve it or disapprove it. I don't have them coming in here anymore, but I mean, we can do that if y'all, if, you know.
Well, sometimes there is an advantage, I think, to looking a guy in the face like he
But the form asks them exactly what the board members would ask them, you know, what have you been doing, how have you been getting ready for the exam, you know, all that stuff. And they just felt, prior board members felt like the form would be better. If you want to come in, I don't, you know, it doesn't matter to me.
That means allotting extra time in our board meeting to handle it. I don't know how many we would have that would, I guess I failed it more than twice and asked to retake the exam. I don't know.
I think we've got probably 7 or 8 now today. 7 or 8, maybe. No, maybe not that many, but
Worth cutting it down if we interview them. Certainly not looking to make more work.
Well, we have statute that finds in our favor in that regard.
Sure.
So we have the ability to do that, clearly. For Jay's benefit, we learned that in Louisiana, if you apply for a surveying, a pre-application meeting with the board. Before your application is ever reviewed by anybody,
Face-to-face.
you make a meeting face-to-face, the board sits down there with you and they talk to you, and if they think that you're ready to take the test, they'll let you fill out the application. If they think you're not, they'll say, come see us next year. It's a pre-application interview. Now, there's other states that we've talked with that they'll do the process at the application stage, just to see it. But Louisiana has a pre-application, which is pretty neat.
It's interesting.
Application interview. Yeah, we'll come in like Sue says. She wants them to come in with their ball cap on and their wife beater shirt.
Yeah.
You know, I mean, you know, that's the kind of pictures we get. You'll see after a while, Jay.
yeah.
Well, let's hope not, because I've asked Donna to, when she sends these applications out, that
But it tells them on the application. Well, it doesn't tell them not to have their white beater shirt, but it tells them on the application not to have a ball cap on. And
that's just my opinion about
Yeah,
it.
there's some merit to the fact of bringing him here, and it shows the level of desire. Like Mr. Elliott, I mean, that showed me a level of desire that he's willing to take his personal time and effort to come in front of the board.
That one, there was about 10, didn't we?
I think
I
so.
had one that was about 10 times.
You have the latitude to say no, don't you? That you've taken it too many times. And
yeah, they can turn them down.
Yeah, we actually, on the application side, we actually have, in some ways, more discretion on the application than we currently have in the rules of conduct on discipline, as far as discretionary measures from this board. And I know that sounds kind of funny, but
I think it may be constructive, maybe, if somebody failed it 3 times, that they come in here and explain why you should let them take it again. It might be, if they're having trouble with a certain part of it, it would be the board's opportunity to find that out and perhaps coach them a little bit.
I guess the ones that bother me the most of the multiple takers are the ones that are regressing. They're not showing any improvement. They say on their retake app that their performance says they're continually regressing. Those are the ones that really, really concern me. You know,
People are just horrid test takers. They're not particularly unintelligent. But there's more to it than taking a test. It just seems like if they take it multiple times, that maybe you should talk to them. Just to see.
and we could decide that that's a meeting
Right.
in lieu of the form.
Right, right.
Require them to, if they fail it 3 times, you could require them to have that would help. Licensees we can get. Familiar with what's on the exam, but should you grant them a license and they're unleashed into the wild and creating plats for people, and that just becomes a headache for us, and maybe given a license, because if they do a hatchet job on a plat and create a bunch of problems for people, then it just becomes our problem later because we get complaints. Well, there's always going to be people like that, but I don't think it's a real bad idea because
Well, I think it's sort of like what Jay said. I think that face-to-face contact, the person that's standing in front of that podium talking to us doesn't have the drive. Invigorated, and they've now got a drive, and they can sense that, hey, part of this. If this is what I want to do, I need to apply myself. And they may have came initially sort of earlier that it's aggressive and, hey, I want my license, and I'm trying to do everything I can. I'm fighting for it, So, all sorts of scenarios. But it may be that there's some folks out there help them, and it might make them better down the road.
I have to agree with you, and at the risk of incriminating myself. Qualified to take it under the 6 years and responsible charge, and so this degree or not, my degree was in chemistry and biology, and so I didn't have any. It's time you come down here and, hey, talk to the board. And I think that there are those that I just didn't know what I was getting into, and it's different than air traffic. There are some subjective things and questions that, that they have to do some paperwork and what.
Well, the
True or
computer,
false or multiple choice, you could.
yeah, the computer questions are not essay type.
Yeah. That's the whole point.
Yeah. Have the math base. I know on the, I just came from math questions are structured to where you can work them, either calculator you bring, and when they do the FS, they're going to actually embed a calculator in there also.
Oh, okay.
So it's really, really interesting. Talk about the FS for a second. All the computer testing centers have to have a 24-inch screen. Reference material is embedded in the program. For the M&Es are allowed to bring in only a calculator, and they have like these white chalkboards. Mm-hmm. They have basically like a pad for you there where you can write on, and then it's basically washed away. You're sitting in a cubicle, and you are in front of your computer screen. You have a camera on you up here. So I mean, it's really super, super secure. But when you're taking the exam, they have a tutorial. The FS exam will be 6 hours, and in that 6 hours, when you first sit down, you log in, and they have a tutorial just to show you how to kind of do everything. And most of the young kids are great with computers anyway. They can bounce around pretty quick. So the tutorial time is up to you. And then when you get into the questions, they have what they call embedded reference. So when you're looking at your screen, if you've got the question on the full 24 inches and you need to look at a reference, then you click on something to get the reference, and it pops up over on this side of the screen, and your question's on this side. So if you needed let's say you needed a curve formula or something, or whatever, and that was what was in the embedded reference, you go to that point, you scroll through, go to that point, you look at your question to answer your question or whatever. They have, the FS has been made 110 questions. 10 of the questions are what we call pretest questions, which means on an exam any time before, but they've been approved to be on an exam. So the cyclometricians that analyze data of those questions after they've been taken 100 times to determine if it's a good question or a bad question. So then you have the 100 questions. So you have a total of 6 hours for the whole adventure. So at approximately allowed to take a break of up to 20 minutes. Tell the computer you're taking a break and hit the button, those 55 questions are scored right then. You can't go back and review them, you can't touch them.
Is the applicant told those scores?
Yes. Really? No, they're not told the score. No, they're not told the score. But they're told that those questions are done.
Ooh.
Then you come back. For example, if the first 55 questions took you 4 hours to take, and you take your 20-minute break, you've got about an hour, a little less than an hour left to get the rest of them done. So, but it doesn't quite work that way. But anyway, then you come back and take the rest of your questions, and when you click your button to send it in, about a 5-minute question and answer thing, what you thought of the test and so forth, if you want to answer it. Sure. If you're happy, mad, whatever it is, you do that. Now, the results are going to be within 48 hours. After the results are published, they'll also be sent to Donna if we have applicants from Tennessee or whatever. She'll have them and she'll know. Fail, they have to wait to the next test window. So in other words, if you took in January and you failed, you'd have to wait to the April-May window. If you fail that one, you wait to the next one. And if you fail the third time, out. 3 strikes, you're out. Then you have to come back to the board. Especially on the FS, yes. Yeah, and that's part of our next item on the agenda of some of the things we were going to discuss on there. So, but that's kind of the general scenario of it. It's pretty neat. It really is.
That sounds neat.
And you and I can be sitting side by side taking the FS examination, and no question alike on either one of our exams. They'll come out of the same categories, but they won't be alike.
It's a big pool of questions.
Yes, it's a very big pool. Item bank is huge. The exam is given on what they call linear. I see a few, but not many. Not many. They may be structured very similar, but they're not the same question. But the item banks are not set up to where, for example, question 1 says, what is 2 plus 2? And then the next item in the item bank says, what is 3 plus 1? You know, they're not set up like that in any manner. It's not just a manipulation of the numbers to get to a response. Each of the item banks are and the exams are categorized based on a listing of a certain percentage of questions in each of these areas. And you may be sitting there taking your exam, and you may start in area number 9, all in that same order that they give you the areas. So it's all over the place. But so
stuff walking in there.
Yeah. So far it seems to be okay so far, because they've had people taking the tests, practice tests, or so forth. Is going to be handled the same way, and but it'll be that'll work. Well, I tell you what, before we get into reviewing those exam procedures and a few more, a little bit of discussion there, why don't we take an adjourn and go get a sandwich and back and reconvene at 1 o'clock? How's that?
Talk you right into it.
Did I twist anybody's arm? Okay. Turn the TV off. We will go eat lunch. And when we come back, we'll come back to work.
Who's this? Do I open it? Is there power?
Okay, it's now 1:15. We've all had lunch, and so we're ready to move forward with our agenda. I guess Donna or Nicole Warren has laid before us a copy of an email from John Cothran with the Engineer Architect Board to Dr. Turner, who's the Southern Zone Vice President for NCWS. A year ago at the annual meeting, the NCWS was soliciting for locations for the Southern Zone meeting for the year 2016, and the engineering board spoke forward and indicated they would like to have it here in Nashville. And because both boards are members of NCWS, they asked us about it, and at that time we indicated to them that we thought that would be a good idea, and we would assist in whatever way is necessary. So the reason for this email is a lot of times two zones like to meet together, and the central zone has requested the southern zone to have a joint meeting in Branson, Missouri. Well, if you've ever been to Branson, Missouri, you can't get there from here. So it's not convenient to a real big airport and so forth and so on. And the engineers have reviewed this, and by this email have indicated to Dr. Turner that they would like to continue with the plans for hosting the 2016 meeting, and they have asked through Donna that the Surveyors Board give them an indication as to whether or not we want to return the same direction to Dr. Turner, or whether we would want to try to have a joint meeting. I'll leave that up to the board, the members for discussion, and we'll go from there.
As far as a joint meeting, I don't care if we have the central meeting. Double the preparation, double the hotel accommodations. The other two have not. Maybe we ought to just consider just the southern meeting, southern zone.
I like what John says also about the attendance. That way, all of our board members and staff could have the opportunity to attend, and also folks from TAPS and so forth could attend, because, as you well know, Galen, there's a lot to offer at those meetings. My vote's to stay here in Nashville. What do you think, Galen?
That's my vote. I think we ought to leave it here in Nashville. Yeah.
Jay, you have an opinion?
Well, it's a little easier to get to nowhere from Memphis as far as Branson goes, and I have no issues with the Branson.
Donna, based on that, I don't think we need to necessarily vote, but the straw poll says that we just notify Dr. Turner that we'd like to continue on the basis of having it here in Nashville, for basically the same reason that John stated, because this provides a better opportunity for us, and it helps the local economy too, and that's positive, and and before I came on this board, it had been several years since the board had attended any kind of NCAAS function. I've kind of pushed real hard about that, and when you go to these meetings, you find out, first of all, they're surprised that Tennessee's been regular here recently, and Rob can attest to that, and so can Galen. And since we have been regular, it was pointed out when this question was asked about the Southern Zone meeting, is that they hadn't had any kind of functions at all, NCAAS, in Tennessee in many, many years. Memphis, and it was when? It was early 90s, wasn't it?
97 was
97, okay. So anyway, it had been quite a few years. So I think we'd like to break that mold and cycle a little bit. And so we'll just notify Dr. Turner, and hopefully we'll be able to have a very positive event. Okay. All right, let's continue with the next item on the agenda. It's review exam procedures and applications. We've kind of talked around this item a little bit off and on through the morning. One thing that I want to point out is with the new exam structure for FS going to CBT, no longer will a candidate be allowed to take all three parts of the examination at the same time. In the past in the state of Tennessee, but it won't happen any longer, because NCAAS specifically says you must pass take and pass the FS examination prior to taking the PS examination. So because of the CBT scenario, they will have to take that, which basically takes us back to statute on the structure, and then they will have to have 2 years progressive experience beyond the FS to qualify for the PS. Now, they will be able to take the PS and TS as it's currently structured at the same time, at a minimum for the next year, or the next 3 exam cycles. And that may change then in 2015. So I wanted to make that point to everybody that when we look at applications, that dog won't hunt anymore. You won't be taking the whole package. So at a the minimum scenario, when you get to the FS level, you're looking at another 2 years before you get to the PSTS.
After this cycle, after October.
Yeah. After October. Yeah. So I wanted to make sure and point that out, and everybody was kind of on board with that, because that's a little bit different thought process than the process we've been working. Talked about, we've created, I think for the most part, the next item, it says discuss schedule and procedure to review FS applications. I think for the most part, we've addressed the review of the applications as far as a scheduled time for that. The procedure, I think we just need to formalize that from the standpoint, and I think we talked about that at our last meeting also. We basically have primarily 3 options. And this is just as much for anything as review for you. Option number 1 is for our board to continue approving applications as we have in the past for the FS. Option number 2, and this language is because of CBT, option number 2 is to allow staff, or in this case Donna, to approve the application for the person to sit for the examination. Option number 3, which all of these options are a scenario that some of the states in the United States are utilizing in dealing with this CBT. Option number 3 is to allow the NCAAS to approve. The thought process behind that is the fact that whether you live in Tennessee or you live in Mississippi or Michigan or wherever, you can take the FS examination once you are approved by one of those 3 mechanisms anywhere in the United States, and even in a couple foreign countries, because of the testing center there. And because once you get approved, your application is approved, they assign you a number, then you look for a seat somewhere to take that examination. So you don't have to, it's not like it is now. You go to Murfreesboro and take the FS exam in a room. You can take it any place. Whole new ball game. So I think the only thing that we need to do is just basically formalize that our direction at this point in time has been that this board wants to continue to review. Donna, that's, I think, again, more important information for you, because that's part of what's going to have to be crafted on the website.
Y'all are still going to review applications just like before, and then I'll send them a letter telling them they've been approved. Go to Pearson View and wherever you want to go. And
their letter will say that the board has approved them and they need to contact the NCAAS,
okay.
Just exactly like what they've already been doing. Same procedure. The procedure from the time that we approve it until the time they are an examinee is exactly the same.
So once they approve it and I send them their letter, I'm done with it until I get their scores back. Okay.
Also, I feel like that in that dialogue on the website, it needs to stipulate that the applicant, the fees for the examination will be obtained at the testing site. And you want to clarify that with the NCAAS. They already have a dialogue language written for that. So once they have approval to sit for the examination, we don't have any other thing to do with them unless they come back because of fate. They know that when they go, for example, we charge, $25 for an FS examination?
Was to charge that for the application. We charge $125 for the applicant, for the exam.
Well, the exam fee goes away after October.
Right.
And what I'm saying is the exam fee for them now becomes $250. Yeah, we don't handle that money any
Right,
longer.
right.
That's what we was talking about earlier on the budget stuff. That's out of the equation now, after October. So I think that you need to make sure and get with the folks at NCEES and make sure that what we post on the website is the structure that the applicant will see once they're approved. When they get on there, then they know, the applicant knows the rules of the road. You know, they got to do this and get a number, and then they got to call and get a seat, and so forth and so on. And I think, if I reviewed it correctly, Jay, we have, I believe, 8 Pearson View Centers across the state. Two in Nashville, there's one in Jackson, in Memphis, and there's one in Martin, I believe it is. They're very handy. I mean, I'm sure there's like a little. I mean, it's just a situation to where if you're on vacation, you decide you want to take the test. If you've been approved, you can just go to that place and take it. Yeah, just go on in. Okay. All righty. I'd put on here on the Committee of Examinations for Professional Surveyors, the PS cut score and exam writing. I attended as a member of what's called the EPS Committee of NCEES. I attended 2 separate meetings. The meeting in May at Clemson was to establish the cut score for the PS exam that was just given in April and will be the cut score for the next 5 years for the PS exam. This particular meeting, I was an observer, and we had, we had 12 surveyors from all across the United States, even had one from Alaska, and actually took the examination. We actually reviewed the questions to make sure that quality of question, make sure it fit in the proper category. We discussed the difficulties of the question, whether, a person at that stage in their progression to be a surveyor, if that was a difficult question, an easy question. We determined a couple questions that had more than one answer that was given, so they were thrown out. So when we got everything said and done, the psychometricians presented the analysis, and the observers, which there were 4 of us from the EPS committee, we reviewed their analysis. We reviewed different statistics. We came up with a cut score. So in other words, that is the threshold score of minimum competency for the PS examination. Very interesting. I had done the FS in 2005, so I've done the FS and the PS. So it was very, very interesting. There's a whole lot more to it than anybody could ever imagine. There really is. And the exam writing came about in June, and we had people working on, in June I worked on FS exam questions. There were other people working on PS exam questions, and then there were people customizing items to go in the item banks and items to go in the pretest bank. Formulating, we had 24 people there. Surveyors, PhDs, all these items and made submissions. And when you write a test question, it goes through about 6 people at different levels of checks or makes the cut to get to the item bank to go to the pre-test. I think it's a really good question. Somebody may can it. But it's very, very, very structured, and it's a very interesting process. And the new president for NCWS, her name is Patty Mamula, and very nice lady, and she sent me in June. EPS committee, if I'm not mistaken, I think I want to say 3 years. Right before you can be back on it again. So, the way it progresses, I've just barely dented the surface in learning. I want people to be on it like 2 or 3 years so that you can work your way through it, and then if you come back, you're in a different position on the committee to help in a different. NCWS committees are good committees. I recommend them. I really do. They're very structured. Knowledge that those people have around in 2 or 3 suitcases. I mean, these people are smart, really smart, unbelievable. Our applicants have no comprehension whatsoever it takes to do that examination. Anyway, that's kind of where that stands right there. So let's move on here to the next item. Let's talk about the letter that was sent out by Larry Doss. That was throw that over to you a little bit.
We have a copy. I did not bring. Larry, and I've known Larry for a long time, and he was at one time president of the Tennessee Association of Surveyors, and he sent us a letter concerning our avenue for licensure to be a surveyor. And the letter primarily dealt with as what we have known as the 10-year rule, or putting the 10-year rule back into effect, is kind of what I was gathering letter. And I thought, well, we probably informed as to what we are doing and how our what that avenue is and what it takes to be licensed. Good letter back to Larry informing him of is going here in the state and what that's doing for this. Probably would be the way to answer him, but I did not want to send him an email back.
Letter was apparently we didn't get that, and forward all of those kind of inquiries to us as administrators on the agenda for you if you want, or if you have any other business.
Didn't Larry email that to you?
No. So this is actually the first we've heard of this letter, and
but I got a copy of it.
I thought you were copied on it. I apologize.
Well, as far as I'm concerned, you can have a copy of this if you want to make a copy of it and take a look at it. Owe him, an acknowledgement of what he sent to us. And like somebody because they don't have a degree or what have you. It's the fact that what can I say, more professional as to what we're dealing with and what we. I think that's it. And I did not come back and explain anything to him concerning his tenure. And that is my hope that all of that goes away. And I do think, Tim asked me to write something for the newsletter, and I only wrote it from the standpoint of how this quote known as the 10-year rule, unquote, when it the progression of that, but I did not include anything dealing with the and it was supposed to have been over with type thing, and I just kind of went step by step through that.
Our offices, it's anything that might become future board business. You just don't want to respond to, other than thank you, and I've referred this to the administrative office for response. We'll get them on the agenda. We'll respond to them on behalf of the That's what we're here to do. We need you all to vote as a board, so we don't want a whole bunch of responses to, right, nor do we want anyone appealing to each of you privately, because it could violate the open meetings rules or could be considered. I don't want to break any of the rules. We need you to be able to vote on future applications for each of these individuals. Just forward those questions, those inquiries to the administrative office. That's what we're here for. So just that to us. And if you need something on the agenda, just tell us, and we'll put it on the agenda so that it can be publicly exposed. We'll even give them the opportunity to attend if they need to.
But I'll take full responsibility for that, Nicole, because I had in my mind that Donna was included on an email. hard, but clearly, other than making sure that the members had this, and that's why that we wanted to wait and discuss it at a meeting. I appreciate your comments, and we'll try to make sure that we do adhere to those, because we don't want to do anything wrong.
Right.
But since we are addressing it, Mr. Dawson also makes mention of he was requesting a list of educational facilities and the degree that was offered that would satisfy the board's existing policy be put together so that it could be distributed to young folks to see where they could go, so that they're not limited just to East Tennessee State or whatever. That's fine and well and good, but we've kind of went away a little bit. Specific university with a specific line of courses in our course review and so forth. We've kind of went away from that a little bit because, it's been about 2 years ago or 3 that we requested the universities to provide course names and a brief syllabus for us to include, to update that information, if I remember correctly, Donna. And basically, the general response we got was, we have the courses, and if you want to see something specific, we'll send it to you. But clearly, we do have a significant amount of universities and junior colleges that are favorable in the review of those courses with all applicants, along with there's other facilities. I don't think that we've created a playing field relative to the educational side of it at all. So I appreciate where Mr. Doss is coming from. I know Mr. Doss also, as Mr. Northcutt does. Fine fellow, he's done a good job. He's educated for many years at Mississippi State. His concern, and I think we share his concern relative from the basis of numbers, but not necessarily how we get to those numbers. We will withhold any further discussion on this until we get a copy of this to Donna.
Letter regarding the current policy. And if he wants an additional meeting, we can set up a meeting for the October. We can afford him that opportunity.
Why don't we just send him the current board policy?
Send him the
relative
current
to the
board
10-year.
policy.
Yeah.
But we do have those opportunities available, so we'll make sure that the letter includes our contact information, and if he wants to.
Let's do that, Donna. Just send him a letter and include the board policy, and thank him for his letter, and tell him that the board is, whatever, considered it, so forth and so on. As further, questions or concerns, he can, send us another letter through you, or come to our meeting. We'll be glad to give him a time slot here on the meeting or whatever. Sir.
There's a census pretty narrow.
Most every licensing law census For example, the gentleman that was here this morning spoke about the subdivision law. Subdivision law in that 13340 or 2, I forget which it is. There is a section in there that exempts a county in the state of Tennessee that has a population between 32,700 and 32,800. Well, I got to looking, and there's like 20 counties in the state of Tennessee that have a population below that, just out of curiosity. But for whatever reason, what you find on these things, Rob, is there's a legislature that's from that particular county at that particular time that doesn't want this law to apply to his county.
Ask that be deleted too.
I think it's great. But atypically, we had a gentleman in Cotton County, Tennessee, that was crafting some kind of law. I don't know if y'all remember it. It's been 4 or 5 years ago. Having a legislator craft some kind of law because he was unable to pass the surveying exam, and he wanted to craft a law exempting anyone that lived in a county with a certain population, and the population of that county was based on a certain census, and they narrowed it to like about 100-person window, about like this. This is what, 300 or something, and only so that he lived in Cotton County and that he could get his license if that law passed. It was the sole purpose behind that law, and of course the association got it killed. But like I say, it may have been a little longer than 5 years ago, but it hadn't been too long back.
Hadn't been
Yeah, but that very thing, to me, that's a legislative maneuver. Yeah.
Ask that paragraph and the one following about 10 years practice. The only option you're going to have is A, B, or C.
Say that in lieu of being able to meet with the engineers, if I really feel like that's a huge leg up for the surveyors. That one thing right there has been the largest hurdle with the engineers through the Attorney General's opinion. Surveyors could be qualified to be licensed without education. And when that goes away, I think the rules of the game may change a little bit.
Practice for 10, if you've got that license and 10 years of practice, you can get a license in Tennessee. Yes, that doesn't say anything about having to do anything. Licensed under that? I live in a county that has whatever it is.
Whatever counties fit in there, technically speaking, at that time, at that window when that was written, we probably could have license. Move, Rob, get rid of that one. While we're talking about rules a little bit there, Rob, you mentioned earlier in the legal discussion about elaborate on that a little bit.
the complaint reviewers are interpreting that literally and not as a range. Ratio has to be that. And that's what it says in the rule. The rule ratio on there, not a range, or a, apparently there are some practitioners that interpret that as you got to put the ratio on there. Heard from y'all that some people are interpreting around 1 to 7,500. Not really what the rule says.
Got the blue book, and I know it's slightly different than the new one. Thank you. Rules that we already used that promulgated word there, Rob. Area of closure shall not exceed 1 foot per 7,500.
At 2003.07. This is what the surveyor plat has got to have on it. For paragraph C, it says ratio of precision of the unadjusted survey.
One and two are two separate things. The certification says that it meets what I read over here, for example, for the category 2. It says that it meets the criteria for category 2. Ratio of precision is what you actually got on your traverse or your control that you ran on the job. And those two numbers are not, and well, virtually never the same. Just put it that way. They're just not going to be the same. In other words, if the registrant is attempting to say that those two numbers are the same,
apparently there's some confusion, or at least a different interpretation.
craft a policy, we'll get our crafting knife out.
Well, the only one I've ever encountered is this particular complaint reviewer. I don't know how widespread the problem is. It's
trap a bear when all we're trying to trap is a mouse, and sufficiently what one needs to put on a plat. And if he puts on the plat the ratio of precision, or if he put he has accomplished what we are, as I, board member, I know that the accuracy or the precision of that survey is at least a Category 2.
Or 7,500.
Or 7,500, it still meets the criteria for Category 2 survey, what have you. So that's, I don't know, I'm not sure that I want to.
The fact that somebody's putting the 7,500 means that they have met at a minimum 7,500 or better.
Let me rephrase this. Instead of crafting a policy, let's give Rob some direction to send back to the case reviewer so that the case reviewer has a clearer understanding. How's that?
Sure.
Is that fair, Rob?
Yeah, I mean, I'm just informed. Not a fatal mistake.
My view of it when we did the standards was the certification is one to ensure that it goes in a particular category, and that category has its own requirement, which if it's a Category 2, it's 1 in 7,500, okay? Minimum. But the ratio of precision of the unadjusted survey is actually a separate item. Now, I think, and it's a pretty common practice in East Tennessee, a lot of surveyors use a certificate that says this is a Category 2 survey, better than or greater than 1 in 7,500.
That's
And that kind of takes care of both of them in one statement. Now that's a local mechanism we use.
I use that very same thing right here, and I'm sure that Leonard probably does too. Somebody wants to be specific. Okay, so he puts down. What do we tell you to tell the reviewer?
All that matters is how the board interprets the rule. And if that's the way
And see, the other side of that is, I don't think that this board can look at a plat and dispute, other than doing a mathematical closure on the property, to dispute that the document you have before you doesn't fit in one of those categories or does not meet that criteria.
Absolutely.
Because, in order for me to make that decision, I'd have to know how the gentleman or lady did it, and review that work in order to accurately decide whether or not they had that kind of information or not.
Calculator out and start doing this thing, or do whatever he does in his software.
If I may, the plat, the perimeter of the drawing will close mathematically. It's in the field where the traverse closure met that requirement. If you go out there as another surveyor and you do the survey and you have a very tight closure, say yours is 1 in 20,000, well, you are not going to match the exact distances on that plan because it's based on a balanced closure, and they're going to be different. So that's what the purpose of that was, to know that it met that minimum requirement.
Because you see, also under the accuracy statements, it gives a positional tolerance as well. So you can have your error of closure, but your positional tolerance can also not meet the standard also. That's determined by a second survey.
Yeah, yeah.
It's not determined by the document you have in your hand.
It gets, not complicated, but it is,
Accuracy and precision is just, that's part of what we do, but it's hard to define just from a piece of paper.
Yeah.
It really is. I would just recommend you kind of pass something with that spirit along, because, I know we don't. Not that we don't know who they are, but at the same token, we don't call them and communicate with them or anything like that at all.
Involved in these things. There's only 4 of you here and 3 are practitioners.
Added an item to the agenda that I wanted to discuss for a little while. Item was relative to map and plat standards in regards to legibility. Something, I did a little investigating on this, and the registrar's laws don't address today's world. We have, with our computer drawings and all of this type of thing, we have a lot better methodology of producing a more legible plat. The state of Georgia has taken a lead in this for many years. Something that we discussed a little bit when we looked at our standards when the last time we modified them. The state of Georgia has some things that deal with character sizes and things of this nature. Even, as you all know, even if you're doing a document in AutoCAD, you can make the characters where they're very legible on the screen, but they could be very illegible on the product. And the surveyors in the state of Georgia worked with the registrars to enhance their portal. They were legible, and they would also be legible on enlargement and reduction. And as you all know, that's one of the big issues we have when we go to the courthouse. If you get a particular document, it's hard to copy it, and if you do any of those other 2 things to it, it may become even worse. So that was part of why I wanted to address this, because I think this would be a good potential at some point in time to add to our law in our standards. They've made, for example, they use a copy or scanned resolution of. Not that great, but at the same token, it does ensure the legibility. And I think that, if we went to craft, had somebody maybe through TAPS or whatever look at that to craft the law, then it was something that the registrars would certainly be on our side about. And also the term. I wanted to kind of throw that out and kind of see what your all's thought was on that. I think we cover, similarly, we cover the same items as far as what's produced on. obviously, we can't do nothing about it, anything's already recorded. But this would
are some counties that either aren't able to scan yet or don't have computerized records. I can just speak for the area that we're in the fact that the scanning
I just wanted to throw it out for see what y'all's thoughts were.
Well, let me interject one thing concerning that. As far as the registrant submitting a plat, I'm kind of like Jay. Not one, when I take it to have it plotted and what have you. Bothers me the most, and I'm not sure how to get around it, and they have documents that the registers on horrible. You cannot read a lot of data that needs to be read by the surveyor. It's left up to my mind and interpretation. Whereas if they had back to the original document, which they do have,
on microphone.
Paper or whatever it was, Mylar, or whatever it may have been submitted on, the document itself is legible. And the Register of Deeds said, well, we will scan those. And that's been 7 years ago and it hasn't happened.
If I could just interject 1 second. Don't want to apply the regulation in the wrong place.
No, that's exactly what I'm saying. I think that it lies of the one that needs to be rescanning documents, but I don't think it's the fault of the registrant. I realize, hey, I have done documents and I've had fonts that are too small. I've gone back and read.
One of my thoughts there was, I don't know if you all have individuals in your area or not. Fairly legible.
That's why I went to computer aided, because
Yeah.
my handwriting is horrible. I couldn't even read it after it got
Oh,
caught.
and like I say, this came, I get, all in, and I said, well, I think it might be at least a good discussion topic. That's all that was just a discussion topic.
Yeah, and not to really, the fact is the fact that it's illegible as it's written, but really all you doctor's handwriting are two different things, but they still meet the character size, and they still meet the font size, and they still meet the pen weight and all that. He's met the regular. To say would be legible, and then it's up to the interpretation.
Right. Like I said, I just want to kind of throw that out.
Yep.
See what y'all thought.
Wasn't on the publicly noticed agenda, so really no action can be taken on.
Let me ask you a question about that, Nicole. If this board functions under the Robert's Rules of Order, Robert's Rules of Order allows an agenda to be allows the authority that's doing the act on any amended agenda item, if it so seems. I understand Robert's Rules of Order, and I may not understand them.
Yes, you operate under Robert's Rules of Order, but you're also subject to the Sunshine Law and the Public Meetings Act, which includes some public exposure or public notice requirements. So anything that could or may affect the licensees, such as possible legislation or anything that you might, if you guys want to discuss, stuff that affects just you, you can bring up new business, or you can bring up a meeting item to discuss it at a future meeting where you would vote. But I just wanted to say it wasn't publicly noticed, so a licensee or a member of the public interested in that topic wouldn't know that you were going to discuss it today, and therefore wouldn't have an opportunity to weigh in on the discussion.
I have to say, that's the first that I have ever heard that dialogue, because since I've been on this board, we've amended agendas most every meeting. I'm not going to say every meeting. Most every meeting, there's been agenda amendments, dialogue of that nature that anyone has ever instructed this board. My understanding was that that's why at the first of the year we part of Robert's Rules of Order allows that. And I understand where you're coming from, but if there are criteria that we need to also adhere to because of the Sunshine Law, we have been made aware of that, as much as so as we're being made aware of it. Always said, sitting in this chair, we want to do things right.
Certainly, and if you, at the next meeting, or I can get it to the documents to you, a little advance of it, but at the next meeting, I'll get you some refresher documents on the open meetings requirements and the Sunshine Law, so that we'll get it from the legal counsel. We had it for another board that I help oversee. I just want to make sure, because that is a very interesting topic, and there's been some other discussions where, it may affect potential licensees when you discuss legislation or potential legislation. Those kind of things could affect the licensees. So we want to make sure that those are publicly noticed, so that if it does affect somebody, they have an opportunity to weigh in. Otherwise, if it does affect somebody, not only the requirements, but as I understand it, the decision of the board could be overturned. So that's one of the requirements of the Open Meetings Act. So I just wanted to make you aware. It's, some discussion. I'm here to make sure that, I'm here to watch out for you too, so,
Certainly appreciate that. Please don't misunderstand, but like I say, I've been on the board for 4 years, and it's the first I've ever, and I'll assure you that we will certainly conform.
If you want anything on the agenda, just let Donna and I know a little advance, and we'll get it on that agenda, and that way the public fully, you read that little statement at the beginning that says, we noticed on this date, so that,
we're treading some new ground here.
so that we don't get any decisions of the board as happened to other agencies where a board's decision has been overturned. That's that all you want.
Oh, it has to be open. If you want.
Ardane's for real, you don't have to put that on the agenda.
But I'm saying that if we wanted to have that drafted into our legislation, or how, in our standards of practice, or whatever we want to publish before we have our meeting, that time.
Like John Smith over in Sevierville could go, well, that sounds interesting, I want to come.
It might be just the thing he wants to talk about.
Yeah, I have no idea.
I just was curious that, it's that type of thing. If it's going to affect the law and affect their practice.
Or potential board decisions, or, anything that you're going to vote on, anything that you might vote on, we have to put it on that agenda.
But I'm not sure that we wanted to really take a vote on it.
I wasn't going to interrupt until I was starting to feel that nervous, like, maybe, so.
Okay. All right, next. Excuse me, didn't mean to stop.
Talking about exams, on 62-18-111. Applicant who fails the exam twice shall not be admitted to another exam unless
That's the retake form. The prior boards determined that the retake form basically took care of that. However, we certainly can change that routine, and
talking about exams before. So somebody that fails twice, they have to provide this board something that shows they've been studying. So
it's just like we have allowed applicants to take the exam 4 times in a 2-year window. In light of the other exam changes with the FS and PS and so forth, I have no problem with that at all.
Because I do think sometimes on that form,
possibility, yep.
sounds good when you read it.
a thing on the form other than their name, that's it. Yeah. They just fill the name out, they didn't fill out any of the
Put anything on there what
requirements
they have done.
whatsoever.
I mean, they didn't even say they pick up, and looked at it.
I think we're wearing a new set of shoes for as far as exams go, and I think we have an opportunity to look at things and maybe change how we've been doing it. We are at approximately 2:30, and the
Probably, that just one box. There's probably 40. All of them, those aren't all new. Some of them are retakes. They've taken it more than twice.
we're looking at a good 2 hours plus, yeah. Hours to 2 hours and a half, I would think, potentially, to go through all of them. Pleasure. I can go either way. Motion and second to adjourn. Our agenda's concluded for the day. We will meet in the morning in this room at 9 a.m. And the purpose of that meeting will be to review applications.